a death where both the heart and lungs stopped working. And the point is that it's due to law enforcement subdual, restraint, and compression.
Did you rule out drug overdose as a cause of death?
Yes.
And that's an opinion you hold to a reasonable degree of medical certainty?
Yes.
The cause of death is a low level of oxygen that caused the brain damage and caused the heart to stop. And they're pushing the handcuffs into his back and pushing them high. Then on the other side, you have the street. So the street is playing a crucial part because he's against a hard asphalt street. So the way they're pushing down on his handcuffs combined with the street, his left side, and it's particularly the left side we see that. It's like the left side is in a vice. It's totally being pushed in, squeezed in from each side. Yes, a healthy person subjected to what Mr. Floyd was subjected to would have died as a result of what he was subjected to.
Can you tell the jury, from having looked at those videos, can you tell by looking at that alone whether George Floyd was suffering from a fentanyl overdose?
He is not. I mean, when you watch those videos and we go through them, what is his respiration do? He's breathing. He's talking. He's not snoring. He is saying, please, please get off of me. I want to breathe. I can't breathe. That is not a fentanyl overdose. That is somebody begging to breathe.
I'm going to ask you, sir, to listen to Mr. Floyd's voice. Did you hear that?
Yes, I did.
Did it appear that Mr. Floyd said, "I ate too many drugs"?
Yes, it did.
Having heard it in context, are you able to tell what Mr. Floyd is saying there?
Yes, I believe Mr. Floyd was saying, "I ain't do no drugs."
So it's a little different than what you were asked about when you only saw a portion of the video, correct?
Yes, sir.
So you would agree the general concept is sometimes the use of force, it looks really bad, right?
Yes.
And sometimes it may be caught on video, right? And it looks bad, right?
Yes.
But it's still lawful.
Yes, based on that department's policies or based on that state's law.
To be lawful, the force must be objectively reasonable, correct?
Correct.
But if it's not objectively reasonable and it's not lawful, then it's just awful.
Correct.
Nothing further.
My opinion was that the force was excessive. Once he was placed in the prone position on the ground, he slowly ceased his resistance, and at that point, the officers, ex-officers I should say, they should have slowed down or stopped their force as well.
Is this a MPD authorized restraint technique?
Knee on the neck would be something that does happen in use of force that isn't unauthorized.
And under what circumstances would that be authorized? How long can you do that?
I don't know if there's a time frame. It would depend on the circumstances of the time.
Which would include what?
The type of resistance you're getting from the subject that you're putting the knee on.
And so if there was, say for example, the subject was under control and handcuffed, would this be authorized?
I would say no.
Is what you see in Exhibit 17, in your opinion, within Minneapolis Police Departmental Policy 5-300, authorizing the use of reasonable force?
It is not.
And why not?
That is, it has to be objectively reasonable. We have to take into account circumstances, information, the threat to the officer, the threat to others, and the severity of that. So that is not part of our policy. That is not what we teach.
Did you consider the possibility of toxins, for example, being responsible for Mr. Floyd's cardiac arrest, including potentially drugs?
In the sense that it might have informed our care, yes. There was, again, no report that this patient had, for example, overdosed on a specific medication.
Was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
Thank you, Dr. Langenfeld. No further questions.
Good afternoon and welcome to Live at 5. As a matter of fact, today, this is Court 101. While the court has rested for just this weekend, arguments still going forth in George Floyd's case, we're opening our court of public opinion to discuss the goings-on around the trial of this century, the trial of Derek Chauvin, who is facing 3 counts for murder of George Floyd. I am Gregory Drumwright, and I will be your unofficial advisor around all things happening with the Floyd case. Unofficial because I'm not an attorney. I'm a member of Ben Crump's legal team fighting for justice in George Floyd's case. And I have had an front row seat on this trial as I have attended it every day since the opening arguments have taken place. This experience is invaluable, but it's still ongoing. There is so much that is still left to bear in the case of Derek Chauvin and in the demand for justice for George Floyd. So I welcome you to this very special Live at 5 Court 101. And would you help me welcome our public opinion guests? Good evening to all of you.
Good evening.
Good evening. Sir. I'm glad to have you on set with us today. I happen to know all of you, and I'm grateful for the dialogue that's about to take place. So, how are you all feeling about the George Floyd case? After 10 days, prior to that, a jury selection process of 2 weeks landed us 12 jurors and a couple of alternates. Out of Minneapolis, the world is watching what's taking place in the Hennepin County Court Center. So just give me your general sentiments before we entertain any questions about how things are going.
I feel like it has been a emotional journey because we're reminded of what happened over the summer. And not only that, we're seeing new footage, we're getting new details that we already were outraged before, just at the lack of humanity. So to see and hear more of that and get into even further details and how people felt in that moment, to hear the outcry of the witnesses at Cup Foods, all of that, I feel their sentiments, and it really is. I've never been tuned into a court case, but this one I am.
Oh, wow.
Yeah.
Oh, wow. Eric, how are you feeling?
To be honest, a little bit confused, a little bit frustrated into this process, coming from, just a regular person's perspective, not having a, background in law or any type of education of that nature with law. It kind of bothers me. You would think, from that regular person's perspective, it would be okay. Send him to jail, handcuff him, but that's not the process. Obviously, that's not how that goes. So I came across with a lot of questions, a little bit confused on how the process works, from the defense attorneys, even to the judge, even to the jury. So it's kind of making me wonder, okay, what's going to happen in the next couple of days, because even though we know it was a killing, you know, things can still be different, or they can try to find a way to try to sweep this truly under the rug at the end of the day.
It could result in no conviction, I believe.
That's
is
right.
what we fear the most.
Yes, sir.
And perhaps people on the other side of morality is just fearing a public outcry. But for us, we're fearing that there would be no justice in this case, right?
Yes, sir.
All right, Drew, how are you feeling?
Yeah, it's the same as Eric. It's just, why is this, I guess, such a long process of something that we clearly saw, something that's honestly obvious, but yet it's like it takes this much witnesses just to show the truth that you've been seeing.
Yeah, you're probably speaking to the fact that many folks on the other side of the courtroom keep asking themselves, why is it that so many experts are being brought forth to prove the same point?
Right.
We might get into that a little bit later. Taylor.
I think this is extremely interesting. As most of you know, I'm in law school right now. And so I'm looking at it from a whole different perspective. I'm bringing in my Black experience, and I'm also bringing in the education side. And it's kind of I'm trying to keep a balance and really listen and watch and understand what's going on, understand why it's taking time, understand what can happen, what shouldn't happen, and compare it to what has happened in the past to see if something will change, because so much changed in the world this summer. So I'm waiting to see if some things have changed in the justice system as well.
Well, your Black experience could actually break your heart when it comes to the court of law. We have known that our justice system has broken many of our hearts through American history. So I say this with all well and good intent. Let's be careful as we proceed in our Black experiences, looking through those lenses, right? But you're right, there is a lot that has changed, and this case is a landmark case for some of the evidences of that perspective. For the first time, we have seen the ranking members of the police department come out against one of their own officers, which is highly, highly unprecedented for a case like this. So, yeah, justice for George Floyd. Elijah, how are you feeling?
Well, I think me and everyone on this set and many Americans feel the same way, just this outrage and just this uncertainty within ourselves, you know, watching the footage that we've already seen, you know, for the past year and never before seen footage. It's like we're reliving this moment over and over and over again. And that actually leads me to a burning question that I just have to ask you. You know, after seeing all this evidence for the past year, after seeing all of these testimonies saying that this wasn't an accident, this wasn't just a random coincidence, this was a murder, what has to happen next? Because it's obvious what we're seeing, but we just want to know, I want to know, what does the prosecution need to do? What does the judge need to do? What has to happen so that we can convict Derek Chauvin?
Well, your question is probably the most relevant question around this trial that is swirling in the minds of most of the people that have been onlooking. Simply because most people do not have a law degree, and most of us are legally illiterate when it comes to the court proceedings and how the criminal justice works for and against us. And so I celebrate your question with this answer. In order for there to be a conviction in this case, the prosecution has the burden of proving to 12 jurors that Derek Chauvin is guilty of 2 counts of second-degree murder and or 1 count of third-degree murder. 3 counts he is being tried on. First-degree murder is off the table because it would mean that It could be proven that he had an willful intent when he got up that morning, or when he heard that there was an assailant or an alleged criminal passing a counterfeit $20 bill, that when he headed in the direction of 38th and Chicago, he had it in his mind, I'm going to kill him. First degree is off the table, right? But second degree and third degree are the counts that he's being charged on. Now, that third degree count is actually very significant, because originally this judge refused to allow him to be charged with, tried on a third count, yes. And the prosecution, they actually appealed that decision, and a higher court overturned the judge's decision and placed third degree back on to his list of charges. So essentially, the prosecution has already won one aspect of this case. Now, some of you all may say, third degree is manslaughter, by the way. Some of you all may actually say, well, we don't want manslaughter. And I would agree. And most people fighting for justice in George's case would also agree, except for those who are practicing law. What it does is it expands the possibilities of some conviction. This jury may not unanimously convict him on 2 second-degree counts, but they may decide, okay, manslaughter. So without a third-degree charge, you only had 2 possibilities of a conviction. So when a higher court accepted the appeal of the prosecution to saying that third degree is fair, and he can be charged, he should be tried on that additional count, it actually expanded the possibilities of Derek Chauvin being convicted. Now, best case scenario is that he'll be convicted of all 3 charges. All right? That he'll be convicted of all 3 charges. Worst case scenario, only the third case, the third degree charge. And moderate outcome would mean that he would be convicted of only a second degree charge, or a second, one of those 2, and a third degree charge. Did I lose you yet? Okay, all right, there's another question. And let me make this clear, because I want to make sure that everybody leaves Court 101 knowing more than they did before they attended our virtual event. The prosecution, again, I said this, but I want to reiterate it, has the burden of proving to all 12. Now, 12 of us in the room, people of color, and not all people of color are on the same side of morals, values, and beliefs, but we all live to some degree in a vacuum, or we all live to some degree in our own bubble. And so most of us don't have right around us directly communicating with us in our friends and family circles, folks that's on both sides of this issue. You have to remember that this jury, and all juries, are supposed to be chosen from various walks of life. All right? But we know through American history, the criminal justice system has been broken for blacks for a long time. So George's case is landmark for many reasons. That this jury may be an unprecedented jury of thought, of morale, right? Around this case, we're watching, we're hoping, that we haven't seen the jurors, but we're hoping that these people, that this is a we know that this is a multicultural jury. We know that much. We know things about the jurors. We just don't really know who they are and how they think. We know what they do. We know where they live. we know that they're a culturally diverse jury. But right now, only the jury knows the jury. If one juror says not guilty, the prosecution has lost this case. You have a question?
Okay. This is a lot, and it's helpful already just in trying to unpack and understand exactly what we're seeing come across our timelines and our screens. But I know you spoke of 2 second-degree charges. So how can he have 2 second-degree charges up against him? And then what does that mean if he's convicted of both? What does that mean in terms of sentencing? Because you only have 1 lifeline.
Well, he can have 2 second-degree charges that allege 2 different criminal acts. You see what I'm saying? So let's just say that you, against the law of the house, the will of your parents, go and help yourself to another piece of cake. You have been forbade. No cake for Tanisha for the rest of the night. Go to bed. Tanisha gets up, breaks the law by going into the kitchen, cutting and enjoying another piece of the cake. And then when confronted, Tanisha lies that she has another piece of the cake. But Tanisha was caught because she broke the cake dish. She was halfway sleepy when she was doing this, and her clumsiness created another crime.
Gotcha. Okay.
Right? So in this scenario, you have lied to law, you have dishonestly represented your actions.
Okay.
That's 1 count. Okay, maybe that's 3rd degree. You just lied. So that's a simpler or crime with less consequence, lower ranking crime. But you created 2 second-degree counts against the law of the house. Okay, you defaced and destroyed property. And then you consume property that you were not legally welcome to. In the case of Derek Chauvin, the prosecution is alleging that he committed 2 second-degree crimes and 1 lower-degree crime, a 3rd-degree crime of manslaughter, 2nd-degree homicide. Did I answer your question?
You did.
Was there a second part to that?
Well, I have several questions, so I'll yield back and allow others to ask their questions.
Okay.
And I'm also checking the chat for you to see if anybody at home has questions.
Of course. Anybody else?
Yes, so my question is, talking about the jury again, so all 12 has to decide that it's either for or against, but why does it take only 1 juror to decide the outcome of the case?
Well, because according to the law, the United States law and the law of criminal justice court proceedings for serious crimes, in this case, a crime that is alleging murder, felonious crime, it is the law of unanimous consent. That all 12 juries have to unanimously agree on a conviction. There are cases where when juries can't unanimously make a decision, the judge, and they come out of deliberation with that finding, the judge insists that they go back, that they deliberate for another period of time, and with hopes that they will go through evidences again and all be on the same page. Because without it, the jury is deadlocked. It only takes one person to deadlock a jury. And without it, there will be no conviction. In this case, Derek Chauvin will be set free. It's the law.
Thank you.
You know, sir, I have a question. You know, going back once again to the jury. You know, we've seen in most instances, you know, during history. You know, if you also look at the Trayvon Martin trial as well, during that time, the jury. I just want to really go in detail. How is truly a jury picked? We know off the age and, you know, as well, but I find it hard to believe that the criminal justice system doesn't have necessarily an input in how the jury is being picked. So truly, what is a factual process of how that goes in picking this jury?
Well, Eric, I just must be honest again and share with our viewers that I'm not a lawyer. I have not attended law school. And so my expertise is not actually expert. However, I've had a front row experience sitting with the lawyers, sitting with this prosecution. I've been there every day for the last 10 days when the prosecution led by State Attorney General Keith Ellison has come into the other courtroom where we're gathered and watching the trial together as a family and a legal team to entertain all of our questions. So all of those folks that are trying this case against Derek Chauvin have become fist bump buddies. And what that has done is it has given me the opportunity to ask a lot of questions, such as what you all are doing right now. And so I just have to share with our audience that, you know, I'm not a lawyer and I haven't attended law school, but I can entertain your question to know this much. Everyone's civic duty is to serve upon a jury. As a matter of fact, just the other day, I got a court summons. May 5th, I have to be in court to serve jury duty. And you all will soon find out, if you haven't already, that you will be tapped for jury duty. And based upon where you reside, where you pay taxes, there are some people living in North Carolina that have to take planes to go back home and fulfill their jury duty. Perhaps they haven't fully established themselves in other places. This happens all the time, right? And so it is our civic duty for every member of the public to serve upon jury duty at some point. These persons have been chosen for that reason, first and foremost. Secondly, they have been selected out of a very lengthy process, 2 weeks, to be the handpicked members of this jury based upon their distance, as I would interpret, with this case.
Yes, sir.
Ideally, the defense would have wanted a jury that didn't even know who George Floyd's name was.
That's not possible.
And that actually, it's not impossible, but 99.9999999 people in America, if not in other places around the world, know who George Floyd's name was. And so at one point, the defense was asking that this case be moved out of Hennepin County, but the judge denied that request. So then the next best opportunity for him to receive a quote-unquote fair trial was to discern and decipher through that 2-week lengthy process, well, who knows the least? So if I was a resident of Hennepin County, Minneapolis, Minnesota, and my name was unanimously brought forth to serve on that jury, the moment they seen my Facebook, Instagram, or Twitter page, I would have disqualified myself. Drumwright knows everything about George Floyd. Drumwright is a friend of George Floyd's family. Drumwright has been saying Black Lives Matter out there in the street for a long time. Okay, well, he's not going to be unbiased. And that's where I'm trying to get to. The legal system has to do as best it can is obligated to pick unbiased people. And so your character is vetted. Your involvement in the community, your workplace, your beliefs and your values are all vetted to learn if you would be an unbiased individual seated upon this jury. Very complicated process. And so you may have heard time to time the very last thing that the judge says for the day. Members of the jury, please keep in mind, you are instructed not to watch any media. They cannot consume any media, any media messages, any political. They can't pick up newspapers. They can't read magazines right now. And when they go in to deliberate, they will be sequestered. They will be taken into a secret chamber where they cannot leave until they actually produce a verdict. Ideally, that's going to be a hotel property somewhere, undisclosed. This is the most secret meeting right now, except for what's going on in heaven. When that time comes, and it may come as early as this week, they will be fed and they will be able to go into their hotel rooms at the end of deliberation days, to take care of themselves, but not with televisions, radios, no access to the internet. They sequester, and isolation is so serious. If by chance they do, they could disqualify themselves upon this jury. Yes.
So
Yes.
1.1% is in the hands of somebody.
Well, but it's unlikely that any member on this jury had not heard of George Floyd. So then what are we looking for? Well, did you watch the entire video? Did you even watch the video? Now, there are people that have not seen the video. And likely those are the people who testified that they haven't, that would have been prime candidates to serve on this jury. Truthfully, as much marching and organizing that I've done in the last 10 months, I had not watched the entire video until opening arguments of this trial. And I actually was there when members of this Floyd family had also witnessed the entire video for the first time. Let me tell you, it was difficult to witness their reactions. Who else has a question? Do you have a question from our online audience?
Yes. One of the questions was, what is the difference between homicide and manslaughter? So people are wanting to know, and that came from our sister, Ty Newman. What is the difference between this manslaughter and homicide?
Can I get back to you on the specific ins and outs
Absolutely.
Of that question?
Absolutely.
Okay.
And she also said she's slowly being found in this conversation.
Oh, wow.
So far, comments have acknowledged that this is very helpful. It's still all very surreal, everything that has been happening. We have another question that comes from Bishop Patterson. What is the makeup of the jury?
So those two questions I'll entertain. I want to share some media.
Oh, absolutely.
From this case. And then on the other side of this clip, we'll answer those questions. So let's go to media clip number 2. Let's learn a little bit about the defense's opening argument, and we'll answer some more of your questions.
And that's what this case is ultimately about. It's about the evidence in this case. The evidence that you will see in this case during this trial. It is, I agree with counsel for the state, it is nothing more than that. There is no political or social cause in this courtroom. but the evidence is far greater than 9 minutes and 29 seconds. In this case, you will learn that the evidence has been collected broadly and expansively. During this trial, you will hear evidence of what happened in the Mercedes-Benz in the 20 to 30 minutes prior to the police arriving. You will hear from Mr. Floyd's friends, Shawanda Hill and Maurice Hall. This will include evidence that while they were in the car, Mr. Floyd consumed what were thought to be 2 Percocet pills. You will see Officer Chang's body-worn camera, and you will hear his interactions. This becomes important as we learn about police practices, because what you will learn is that when an officer responds to what is sometimes a routine and minimal event, it often evolves into a greater and more serious event. The evidence will show that Mr. Floyd and the officers began to struggle as they attempted to get him in the squad car. And you will learn that Officers Derek Chauvin and his partner Tu Tao arrived to assist Officers King and Lane at 8:16 and 48 seconds, almost 8:17. Upon their arrival, the first thing that Officer Chauvin sees is Officers King and Lane struggling with Mr. Floyd. Mr. Chauvin asked the officers, "Is he under arrest?" Yes. And then Officer Chauvin began to assist them in their efforts to get him into the squad car. You will see that 3 Minneapolis police officers could not overcome the strength of Mr. Floyd. Mr. Chauvin stands 5'9", 140 pounds. Mr. Floyd is 6'3", weighs 223 pounds.
The biggest stories the moment they happen from around the globe. Subscribe to Bloomberg Quick Take now for insight in an instant.
And so we have a flashback of the opening arguments of the defense. And let me hasten to the point around what's going on with this defense. They are alleging that Mr. Floyd is responsible for his own death. In that, he, illegal substances, drugs, fentanyl, and so forth, was found in his system. And they were also found on the floorboard of the car that he was in just before he was taken into arrest with his saliva DNA upon it. They're alleging that had Mr. Floyd not encountered police that day, that he would have still died. They are alleging that regardless of the excessive force and the overdose of a knee on his neck, that Mr. Floyd actually died from an overdose of prescription drugs illegally obtained and consumed. To answer the question, though, that was on the floor from the virtual audience, the difference between homicide and, what was it, manslaughter? Manslaughter alleges that the murder was unintentional, that an individual is being charged with murder, but not because of an intentional act. That though at the hand of the alleged crime, the person who committed the alleged crime, that the loss of life happened unintentionally. Homicide, and these are very watered down means and definitions of explaining something that is far more complicated. Let me say that. additional $100,000 investment into a legal education might get you an even better answer. But this is 101, right? Not court 500. Homicide alleges that it was an intentional act. It's just that simple. Intentional, unintentional, right? Is the difference of homicide and manslaughter as it relates to how a person is being charged. Now, each crime carries different levels of penalty, right? So I do know off the top of my head that the homicide charge carries a penalty of 25 years or more to life, right? And so we hope that both counts, second-degree counts of homicide are upheld, right? Let me go to another media clip. I want to share more about opening arguments, this time from the perspective of this rock star prosecution. Check this out.
Officers take an oath when they become police officers. They take an oath that I will enforce the law courteously and appropriately, and as you will learn, as applies to this case, never employing unnecessary force or violence. And not only that, I recognize the badge of my office as a symbol of public faith, and I accept it as a public trust to be held so long as I am true to the ethics of police service. Symbol of public faith, ethics to police service, sanctity of life, all of this matters tremendously to this case, because you will learn that on May 25th of 2020, Mr. Derek Chauvin betrayed this badge when he used excessive and unreasonable force upon the body of Mr. George Floyd, that he put his knees upon his neck and his back, grinding and crushing him until the very breath, no, ladies and gentlemen, until the very life were squeezed out of him. You will learn that he was well aware that Mr. Floyd was unarmed, that Mr. Floyd had not threatened anyone, that Mr. Floyd was in handcuffs, he was completely in the control of the police, he was defenseless. You will learn what happened in that 9 minutes and 29 seconds. The most important numbers you will hear in this trial are 929. What happened in those 9 minutes and 29 seconds when Mr. Derek Chauvin was applying this excessive force to the body of Mr. George Floyd. We have two objectives in this trial, ladies and gentlemen. The first objective is to give Mr. Chauvin a fair trial. Mr. Chauvin has a presumption of innocence. He is presumed to be innocent until proven guilty. We plan to prove to you, beyond a reasonable doubt, that Mr. Chauvin was anything other than innocent on May 25th of 2020.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights.
I am really happy to share with you all, if you haven't learned this yet, that the gentleman you just saw arguing for the opening statements of the prosecution is Jerry Blackwell, a newfound friend of mine, not because of any other reason that he's from North Carolina. Mr. Blackwell, on day one, actually, when he found out I was from North Carolina, shared with me with great pride that he was from our state. He hails from Kannapolis, North Carolina, which is right above Charlotte. And he was educated with his master's and law degrees at Chapel Hill, UNC Chapel Hill. So we're both Tar Heels fans, right? Mr. Blackwell shares with me that he literally almost went into the ministry. Really? Yes. He shares that he had a spiritual awakening when he was in college and felt like that law was the wrong thing for him to do. Sat with a group of preachers and they convinced him that you can do work in more ways than one way. God's work in more ways than one way. And what if from all the way back then, I would presume at least 4 decades ago, God was preparing him for this moment. Wow. To do God's work this way. In my own words, I have said to the Floyd family and the prosecution team that of all of the lawyers that's arguing for prosecution of Derek Chauvin, he has the anointing for this case. Another interesting fact about Mr. Blackwell that I learned over these last couple of weeks, he is volunteering his time. He and other members of this prosecuting team are not employed by the state of Minnesota. These are not staff attorneys. These attorneys have been selected, and he is volunteering all of his time to argue this case. He could be paid, but he decided to receive no compensation for the hundreds, I mean, we're talking close to 1,000 hours that he has poured into this case. In fact, it was explained to us that by Attorney General Keith Ellison that Mr. Blackwell is paying to work on this case because he has hired a bodyguard at his own expense. Could have turned that expense over to the state, but he has decided that he would even take upon that expense in arguing this case. How can he do it? Jerry Blackwell is a successful corporate attorney. In fact, he's never argued a criminal case. This is his first criminal case. Yeah, it's pretty cool. Yeah, and our little itty bitty audience here on Live at 5 is getting this insight through my involvement, right? So you all are blessed to be hearing what I'm saying. And I mean that from a humble perspective, but you know, I know we don't have thousands or even hundreds of viewers, so you're getting an insight that not a lot of people know. Jerry Blackwell has not ever argued a criminal case. This is his first rodeo, arguing a criminal case. What made him fit? Well, the cat is out the bag. You can see that for yourself now. He's very capable. But he has won many highly prominent corporate civil cases. He has argued and won hundreds of millions of dollars in prominent civil cases. And what he said out of his own mouth is that if I can win hundreds of millions of dollars for major American corporations, I can argue justice for George Floyd. Wow. And he's doing an amazing job. So let me answer the other question from the virtual audience, and then I'll take some others. And I don't know, are we boring our viewers? This is an extensive Live at 5.
They are absolutely, the chat is lighting up. You know, people are acknowledging how amazing it is that Attorney Blackwell would do this, and then also people are explaining how this is enriching their experience. So I think we're probably going to have more people tuning into the case and the trial. So we had another question come out.
I have a question pending.
Sure.
What is the makeup of this jury?
Yes.
There are 12 jurors and 2 alternates. 3 of them are black men. One of them is a black woman, and 2 of them identify as people of color. The remainder of that balance is presumably white folks. How does that fare up to the landscape of Hennepin County? This jury is more diverse than the city of Minneapolis, the county of Hennepin, or the state of Minnesota. Wow. And so what The court system, the legal system there in Hennepin County is going to enjoy being able to say, whatever the outcome of this case is that this was not a jury that was not properly designed. Right. They were properly seated as it relates to diversity. Also, we know that this jury ranges in age from 20s to their 60s. And right now, that's a very broad stroke of what we know about the jury. Yeah. Before I take another question from the virtual audience, can I get another question from the floor?
Yes, I definitely have a question. First of all, I'm just grateful for everything that's going forth right now. I'm shaking in excitement, right? But my question is, in our last media video, Mr. Blackwell actually spoke about reasonable doubt. And I wanted to ask, what is reasonableness or reasonable doubt? What is the significance of that in this trial and in this case, in the jury?
You know, Taylor, admittedly, my knowledge of the answer, the truest answer to that question is very shallow, but I'll give it a shot. For those who, like myself, have never been to law school, we can appreciate at least knowing this much. That the prosecution has to successfully argue with the evidence that they are using that Derek Chauvin intentionally killed George Floyd, or at the least, he is responsible for his death. If there is any doubt within reason, the evidence is insufficient, the argument did not convince me, and the defense successfully made me believe that Derek Chauvin didn't know that he was killing George Floyd and didn't intend to kill George Floyd in planting the knee on his neck. That is a reason not to convict. So some of the watchers may be saying, why do we have to hear testimony after testimony after testimony, expert after expert after expert, witness after witness after witness, commenting on the same evidence? Wasn't it clear with just the video alone? Wasn't it clear with just bystander 1 and 2? Why do we have to have bystander 4, 5, and 6? Didn't the first medical expert, the doctor from Dublin, Ireland, didn't he prove to us? Didn't he just knock it out the park? Yes, he did. But for a jury that has to be unanimously convinced, no, we need medical expert 2, 3, 4, 5, and 6. And we need all of those if it takes that many or more. To prove, Taylor, beyond reasonable doubt. Yeah. Is there another question?
Yes, there is. So sometimes we hear in the media, some people don't necessarily understand Ben Crump's role in a case. For instance, there's been the Breonna Taylor case where the Attorney General there didn't want to try that case. And so some people may say that Ben Crump lost that case. Can you kind of help us understand exactly what Ben Crump does?
Yes, and this will be my final point for the evening. I take great pleasure in helping our viewers to know that Ben Crump is a civil attorney. Ben Crump is not an attorney that practices criminal law. And there is no such thing as a private criminal prosecuting attorney. All right? To help people understand what I mean by all of this is quite simple. If John Brown gets gunned down tonight by the Guilford County Sheriff, a deputy in Guilford County, John Brown's mom cannot bring a case against John Brown. No individual has the ability to criminally prosecute a case against another individual, private citizen. However, the district attorney, the chief most attorney in Guilford County, may be contacted by John Brown's family and will be engaged in John Brown's case to learn if there is enough evidence for the deputy that killed John Brown to be liable for his death outside of the realm of the lawful practice of policing people. John Brown's mom, again, even if there is video, hint, hint, that this cop, with a misuse of force and outside the realm of legal and lawful policing, killed her son. Maybe there was a vendetta, and video could clearly and plainly show that this cop acted outside of lawful policing. The district attorney is the only prosecuting agent that can bring a criminal case against an individual. Now, there is no Ben Crump right now in that scenario. So why does Ben Crump end up on TV with John Brown's mom? Because whether or not Guilford County is able to successfully convict this police officer, there is another case that has great fixings and great trimmings around it for guilt, and that is a civil case. Whether Derek Chauvin is criminally convicted, the city of Minneapolis is responsible. Well, the city of Minneapolis accepted responsibility in this case, and through Ben Crump's intervention, paid out a $27.5 million judgment to civilly, generally when you hear those terms, it means money, settle this matter with this family. What Ben Crump and civil attorneys do all across America for families in cases like this, George Floyd, Breonna Taylor, is that they pursue finding monetary judgments to help ease the pain and the burden of these families. Ben Crump, you will not see him argue one iota in this case in the courtroom. What Ben Crump has successfully done in this case, what he's successfully done in Breonna Taylor's case, what he's successfully done in Trayvon Martin's case, which a lot of people don't realize. They think that Ben Crump lost that case. Ben Crump did not prosecute that case. All right? He's a private attorney. He is not responsible for the fact that a jury did not convict George Zimmerman. And he will not be responsible for if this jury doesn't convict Derek Chauvin. But in every one of his cases, he has been successfully in getting civil judgments. And that's a major, major, major feat, because what you have to do is prove to cities and municipalities that, okay, who are saying, we're not responsible for Trayvon's death. We're not responsible for George Floyd's death, that in some way you are. Right. That a Chauvin could exist as an agent of your agency. And they could push back and say, prove it. But because of the influence of a Ben Crump, we're finding that many folks are not willing to do that. And so people need to understand when they say that Ben Crump has lost a lot of cases, that's entirely not true. Now, let me be clear, I don't want to give out any unfactual information. In Trayvon Martin's case, it wasn't a police department. Remember, George Zimmerman was volunteer citizens neighborhood watch. And so the agency that would have paid a civil settlement would be different from the law enforcement or the municipality, the local government. You understand? So it's important that people understand what a civil attorney's job and duty. So in my hypothetical situation, Ben Crump would bring a civil case against the Guilford County deputy. Yes.
And I think when that prove it point comes in, when they have to prove what it is, I believe videos like the George Floyd video and things like that, they're super important. Like, I see black people getting pulled over, and I want to pull over too, just to like record and like make sure something happens. So if something does go down, we have that evidence. So we thank God for the age of videos on our phones, you know.
Precisely. And can you imagine, so camera phones have been invented and onboarded in your little lifetime. Can you, I'm sorry to make you, seem so little. But in terms of being 23 years old, that's not a long time. And so this most recent invention has given us the opportunity to document these injustices at the hands of law enforcement. Can you imagine how many thousands or maybe even millions of people that have solid cases that could never be proven? As a matter of fact, because we don't monetize our broadcasting and we are not a media entity, a corporate media entity ourselves, I can actually plug that this Sunday night on CNN, there's going to be a very special documentary about a black woman who successfully sued and literally dismantled the Klan through an all-white jury. So let me plug that. Get on CNN.com and find out exactly what time. Generally, the documentaries air around 7 or 8 o'clock on Sunday night. It would actually help you to see a lot more about how difficult it could have been with no video evidence. Without a camera phone, we wouldn't know who George Floyd. We wouldn't know who Ahmaud Arbery is. Now, a lot of people need to understand why Attorney Ben Crump deserves respect. Because he got a $12 million settlement for Breonna Taylor's family with no video. With no video. And Mr. Crump is highly humble to say he didn't do that single-handedly. It's trying these cases in the court of public opinion that actually makes his job and any civil attorney fighting for social justice cases much easier. It's being able to pull a community, a nation of activists and organizers together to put pressure on public entities or corporations that there is some liability. And so what's happening right now in Georgia, and this is the most extensive Live at 5 in a long time. But I'm gonna wrap it up here. I know I'm boring a lot of people. What's happening right now with those laws, those voter suppression laws that have been passed in Georgia, and now they're tossing the baton to Texas. Taylor, that's where you're from. The public is rising up. We are seeing unprecedented moves by Fortune 500 corporations that are using their power and their influence to push back. The loss of a major league all-star game is huge. You know, to people of color, again, many, not all, but many, you know, basketball is our favorite pastime, but baseball is, quote unquote, America's favorite pastime. That's huge. That's huge. You like baseball as well?
No, what I'm saying.
Oh,
America's.
you just embarrassed both of us. I thought you were waving your hand like, yeah, I like baseball too. You were doing air quotes. Public pressure. I'm not an attorney, and you're not a jury, but what we are a part of is the court of public opinion. And believe it or not, it holds a lot of weight. And therefore, orgs and activists like J4TNG, Justice for the Next Generation, has a primary place in cases like George Floyd's and like what's going on even right here in the state of North Carolina. Listen, I cannot tell you all how much of an honor it is to escort this family to and from the courthouse each and every day. My job is really to sit there and pray with them. My job, unofficially, is to provide spiritual support, mental support, and any other form of support that I can provide for this family after having organized all across America for the last 10 months for justice in the loss of George Perry Floyd. Citadel, because I'm there, you're there. I will have a plethora of experiences and videos and media that I can share at the conclusion of this trial event that will help frame my experience even better. Listen, I can't tell you that I would have dreamed after doing all of this activism in George's memory and his legacy and honor that I would actually be there at the courthouse, watching and witnessing this trial taking place. I've had the opportunity to meet George's daughter, Gianna, spend some precious moments with this 9-year-old, very beautiful young lady who looks just like her dad. I've had the opportunity to meet members of George's family that you all have never seen and may never know. And of course, to be there with his family that is not as widely known. His brother Terrence out of New York is a wonderful young brother. I've also had the opportunity to sit and glean from, of course, Ben Crump and our chief civil rights elder right now in America, Attorney Al Sharpton. And I'm happy to announce on this show, I'm going to make a groundbreaking announcement. It's groundbreaking in my life that I have been invited to be a speaker next week in New York City for Reverend Al Sharpton's National Action Network Annual Conference. I'll be there speaking, and I'll share with you all that the invite came like this. Reverend Drumwright, Bishop T.D. Jakes' daughter, Sarah Jakes, can't make her appointment with us. Can you fill in for her? More about what's going to happen next Friday and Saturday in New York through my humble involvement. You all know I'm already shaking in my boots. trying to figure out what am I going to say in front of Al Sharpton and the nation's brightest and most brilliant activists. But I'll take it, and I'll do the best that God anoints me to do. However, we may be headed into a verdict this week. If not this week, soon to come. So please, Justice Crew, keep an eye out for what's happening in this case. Make sure that you brush up on all of the testimonies and proceedings around this case. We've activated long and hard for there to be justice for George Floyd. I don't want to talk about what could happen if we don't get a conviction. That will have to be another Live at 5. We'll be here for another hour and 10 minutes. Thank you for hanging with us, and thank you to my public opinion jury right here. You all are so bright, you're so brilliant. And Sister Taylor is a 1L. She's a law student right now, studying at Purdue University. And so we expect you to be the expert soon to come. But all of you all are brilliant in your own way. This has been a very special Live at 5. We'll see you on the other side of justice.